Morning, ladies and gentlemen, members of the media, and to the listening and viewing public. I am pleased to address you this morning on the matter of the Darryl Smith report. I am joined by Permanent Secretary, the Head of the Public Service, Mr. Maurice Sweet. He is the Permanent Secretary at the Office of the Prime Minister and is the de facto head, if not de jure head, of the Public Service. I've felt compelled to call this conference in view of the headline news reports, particularly in the Newsday and the Express, which I have deep concerns with and over, particularly because the news as reported is a combination of events which are factually incorrect and swooping in conclusions, and certainly in the case of the Express, only give a very short mention of the numerous interactions that I have had with one of the writers in that newspaper. Permit me, therefore, to now address the specific matters that lie in the public domain. I'd like to say that the matter of the Darryl Smith report is one which has occupied dominance in the media, largely because, and necessarily because, there has been a need to balance rights. As the holder of the Office of the Attorney General, I am compelled at all stages to look at the balance of rights. Obviously, the Honorable Prime Minister is under a very strict and careful obligation to act with the fairness of process and outcome always in mind. The Prime Minister is specifically constrained to act as it relates to reports, the production of reports, in that process that I've just described. But the Prime Minister enjoys a prerogative and privilege as Prime Minister in a very sole domain of his appointment of ministers, their functions, and the tenure which they serve. All members of cabinet who function as ministers or parliamentary secretaries are so appointed under the Constitution by the Prime Minister's direction. The Prime Minister has the prerogative and the privilege to appoint and to also remove persons from office. That's the one area where the Prime Minister acts without fetter. So, on the one hand, the Office of the Prime Minister, the holder of the office, the Prime Minister, must act with procedural fairness, transparency to ensure an outcome as it relates to matters of inquiry, particularly of a public nature. On the other hand, the Prime Minister is constrained only by his decision as to the manner in which he appoints or removes persons from holding the office of minister or parliamentary secretary, or indeed senators on the government bench. The production of the report, which is now the subject of a lot of speculation and also commentary and misinformation, is perhaps in that state and condition because there was a voluntary exercise of requesting a report, an inquiry into the matter of the allegation standing against Mr. Darryl Smith. As you're well aware, Mr. Smith was the subject of an allegation. There was a significant amount of newspaper reporting which made an allegation that an employee who acted as his personal assistant at the Ministry of Sport supposedly attended and then in fact filed a trade dispute indicating that she was unfairly dismissed. The evidence which came into that particular trade dispute in the context of evidence and arguments included allegations that there was sexual advances supposedly put by Minister Smith against this person. Those allegations were stoutly refused. The matter was a trade dispute between the CPO and the ministry itself. Mr. Smith, as the minister, was the subject of certain statements made there, which he has refuted at all points in time. And the ministry engaged in the process of dealing with that trade dispute. The ministry, in treating with that trade dispute, actually entered into conciliation discussions and had specific advice which continued up to a particular point. I can confirm today that via the permanent secretary and CPO combined appearance in that process of a trade dispute, that there was in fact an offer put for settlement of the matter of an unfair dismissal somewhere in or around $75,000, if I'm not mistaken. And yes, I can confirm that the offer put by the ministry was $75,000. The ministry, after it had engaged in a process with the union, as they're obliged to do in conciliation, as you're well aware, the process of reporting a trade dispute involves a conciliation exercise and discussion between the parties. The ministry, after it had presented its offer of $75,000, then retained, and let me repeat this, the ministry then retained the services of Mr. Michael Kwamina as its attorney at law. Mr. Kwamina, as you're well aware, is a lawyer of eminent repute who is a practitioner of long standing in this area of industrial relations. And Mr. Kwamina, at that point, entered into and rendered specific written advice to the Ministry of Sport, indicating that the matter was one which was effectively bound to be lost. Mr. Kwamina then engaged in providing an analysis of the law and in citing examples of cases which demonstrate, for instance, that an employee who had worked for 1 day and was dismissed in a summary fashion was awarded compensation of somewhere around $90,000 in terminal benefits by the industrial court. Mr. Kwamina then went on to specifically advise the ministry of the application of exemplary damages from a high court perspective and how the industrial court could consider that. And then Mr. Kwamina managed to reduce the dollar claim from $225,000, which was what was being asked by the trade union on behalf of the worker. Mr. Kwamina managed, through his usual fashion of negotiation and pursuant to his advice, he managed to reduce that claim from $225,000 to $150,000. So let me make it abundantly clear. Mr. Kwamina was not retained at the inception of this matter. Mr. Kwamina entered where there was a discussion as to settlement. On the one hand, the ministry and the CPO offering $75,000 for a summary dismissal, which was unfair, and the worker effectively through the union requesting $225,000. Mr. Kwamina, by virtue of his advice, effectively negotiated a settlement of $150,000. His clients do not include Minister Darryl Smith. Let me make that abundantly clear. The record at the ministry will demonstrate that. Mr. Kwamina's advice is in writing, and it demonstrates that he came in after the fact. That matter was settled with a non-disclosure arrangement. That is not uncommon in matters such as this. It was open to the worker to continue with the claim. It was open to the worker specifically to advance a claim of sexual harassment. The worker chose in these circumstances, as the record now demonstrates, to settle the matter. So that issue of pursuing an allegation, and I say allegation of sexual harassment, is one which ended with the complainant, the worker, via the union, accepting a reduction in the money that was being requested from $225,000 to $150,000. This matter came into the public domain, and it is now a matter of public record that the Honorable Prime Minister, upon learning of this matter, voluntarily caused a committee to be assembled. And if I put the facts in the public domain, I will remind you that it was somewhere in or around March 2018 to April 8th, 2018, that a series of articles appeared in print and electronic media which unveiled allegations of sexual harassment supposedly by Minister Smith. That certainly prompted the Honorable Prime Minister to cause an immediate inquiry, and the Prime Minister coming into this matter for the first time, as is now public record, on the 9th of April 2018. In other words then, with articles ending on the 8th of April 2018, on the 9th of April 2018, the Prime Minister acted, of course, in accordance with his constitutional powers under Sections 3.9 and Sections 76.3 and 79.1 of the Constitution. The Prime Minister, as I alerted you to a little while ago, has that specific power to appoint and to dismiss or remove persons from office. And the Prime Minister, in fact, in investigating this matter, chose, and it's a matter of public record, to reassign Minister Smith away from the Ministry of Sport to the Ministry of Housing, as is public record. The Prime Minister's investigation into these matters, as he has repeatedly put into the public domain, continued during this exercise, and a mere 1 day later, on the 10th of April, the Prime Minister advised Her Excellency to revoke the appointment of Minister Smith. The Prime Minister publicly said that he did so following upon meetings which he and the Minister of Planning conducted with several persons, including the Honorable then Minister Smith, and the Prime Minister saw it fit to exercise the privilege and prerogative that he enjoys under the Constitution of removing Minister Smith from a cabinet ministry and relieving him to act simply as the Member of Parliament. Obviously, you know, the Prime Minister has no power to revoke anybody's elected appointment. If you are elected to the House of Representatives, you can choose to resign. If you resign before the 4th year, you can obviously have a by-election. We've experienced that before. Or if you resign after the 4th year has passed, there's no by-election. I draw into example Herbert Volney's resignation prior to the time frame under the Constitution, which triggered the St. Joseph by-election, and Anil Roberts' resignation from Dabney O'Meara, which had no by-election because he had crossed the time frame. The Prime Minister, 2 days after acting on the 10th of April, voluntarily called into form a committee. The persons of that committee were Ms. Jacqueline Wilson, Ms. Elaine Green, and Ms. Folade Motota. The Prime Minister informed the public that he was calling this committee into action, and the Prime Minister specifically said that the committee would review the circumstances surrounding the dismissal and payment of compensation to the former personal assistant to the Minister of Sport, and that the committee would be asked to probe the circumstances surrounding the allegations of alleged sexual harassment supposedly made by Minister Smith to this personal assistant. Following that, the committee was given a specific term of reference. And that specific term of reference included reference to probe the circumstances surrounding the allegations of alleged sexual harassment, to probe the circumstances leading to the dismissal of the personal assistant, which led to the filing of the grievance before the industrial court, to probe the process used to arrive at the settlement agreement between the parties, any legal opinion provided, the deliberations leading up to that arrival of settlement, to probe the contents of the settlement agreement and the resultant non-disclosure agreement, to probe the process utilized whereby approval was obtained to effect the $150,000 to the personal assistant by way of settlement, and to make observations, and I repeat, to make observations, findings, and recommendations within 2 weeks of the committee's date of appointment. So that committee was specifically tasked to make observations, findings, and recommendations within 2 weeks of the committee's date of appointment. Following various hearings the committee prepared a draft report and submitted it to the Prime Minister on the 4th of June 2018. I wish to stick a pin at this moment, and I wish to take very public exception to the reportage of one reporter, Ms. Denise Wren, as it relates to the coverage of a supposed inconsistency as to whether the Prime Minister said that Minister Smith was interviewed or not. The Prime Minister has never said that Minister Smith was not interviewed. The Prime Minister said that Minister Smith was not afforded the proper opportunity to answer allegations and findings as a result of the process. The Prime Minister is respectfully not an attorney at law. I watched the interview yesterday that the Honorable Prime Minister had at the post-cabinet conference, and the Prime Minister spoke in very general terms as to why the report produced was useless and what advice I, as Attorney General, gave to him in relation to that report. It was never put to the Prime Minister by way of a specific question, Prime Minister, are you saying that Minister Smith was never interviewed? Because the Prime Minister would have said Mr. Smith was interviewed, but Mr. Smith was not given the full opportunity for natural justice to be had to answer allegations and adverse inferences that were put in that report. And I say, and I've singled out Ms. Wren, I hope that it was a mistake on her part, and I can say this now in fairness to Ms. Wren, that I had several conversations with Ms. Wren over the last few days. I am always cautious to answer questions squarely. I ask reporters to treat with what is on the record, and most times I ask them to repeat what is on the record, and then I very often go off record to explain what I have said, to have a conversation with the reporter so that I am sure they have understood what I said. I explained in detail in an off-record conversation to Ms. Wren that I had to state a very square and careful answer that the report was not capable of being used because it breached the principles of natural justice. I explained and I specifically record and have a record that I explained that Minister Smith was interviewed. What was not done was the process where these allegations are put to him. I gave several examples to the reporter. I explained the principle of Maxwellization, which I will come to in just a moment. So I wish to say that I do pray that it was the editor's cutting of the article that resulted in one paragraph only in today's Express newspaper saying that I was contacted and what was said. I had at least 3 conversations on this topic with the reporter, and I took my time over the course of at least 15 minutes to explain the situation. All of you who are reporters in this room who have engaged with me over the 10 years nearly that I have been in public life can testify that what I am telling you now is the practice that I adopt with every one of you. I answer all your phone calls as best as I can. I return your phone calls, and I'm often told, Minister, or back when I was public relations officer, thank you for at least returning our calls. You can all testify to what I have just said. Let me come back onto the record of this line that I'm on. So the Office of the Prime Minister received this report on the 4th of June 2018. I wish to make it abundantly clear. I was provided with a copy of this report. The Permanent Secretary was given a copy of this report. 2 reports were in existence. I can tell you that the copy of the report that I have, the only copy of the report that I have, has been in my personal possession, locked away in a cabinet drawer. The Permanent Secretary also confirms to me that there was 1 copy of a report and that that was under careful management. And the reason that that is the case is that the report made conclusions and findings in breach of natural law. I say that now because I have had the benefit, immediately upon receiving that report from the Honorable Prime Minister's office, I took the step to ask the Prime Minister for an opportunity to review the report. When I looked at the report, I was of the solid and unswerving view that the report offended natural justice. Out of caution, knowing that this matter is in the public domain, I sought to underwrite my own view and opinion by requesting the opinion of Mr. Douglas Mendez, Senior Counsel, ably assisted by Mr. Rishi Das, who is a well-known junior counsel in the public law arena in particular. Let me underscore right now, Mr. Mendez is known for his independence. Mr. Mendez is in fact suing the Prime Minister in a judicial review of the Section 137 matter. His junior in that matter is Mr. Rishi Das. Mr. Mendez is the person who occupies the office of President of the Law Association. Mr. Mendez is no slouch when it comes to independence and to the robustness of his opinion. He sits in the Court of Appeal in Belize. He has sat in a number of matters, and he is a man of impeccable character when it comes to carrying out functions. The process of suing the Honorable Prime Minister for the Law Association is on not his personal desire, but he has seen it fit to act upon the instructions of a low turnout of the Law Association, but he's done so commendably. Now I'm stopping for a moment, and unusually so, to tell you the choice of attorney in taking this advice. Mr. Mendez and Mr. Das produced written advice for me, and one copy of this, the copy that I have here is dated the 9th, it's sort of fuzzy, it may be the 7th of December 2018. This advice confirms in pellucidly clear terms that the report which was produced offends the principles of natural justice, and it goes into details. Yesterday I received, and quite properly so, a Freedom of Information request from Ms. Wren of the Express. I'm obliged to treat with the Freedom of Information request. In treating with Freedom of Information request, she has asked for a copy of this opinion. The opinion is privileged. The general principle is that you ought not to reveal an opinion of this type. However, I am obliged to consider the ramifications and impact of Section 35 of the Freedom of Information Act, which obliges me to consider the public interest argument. In considering the public interest argument, I must balance the rights of the disclosure of the opinion in its full terms, and I should tell you that this opinion repeats the findings which Mr. Mendez, Mr. Das, and I all view have gone too far and that are devoid of natural justice, and I don't think so intentionally. I'll explain that in a moment, as well as the reasons why. In the circumstances, I am today in balancing the Section 35 interest under the Freedom of Information Act, I am going to disclose publicly this advice with a certain redaction. I'm going to redact only parts of paragraph 6 of this opinion, because it is at that point that the findings which are offensive are set out in written form. So the opinion repeats what the report says. The report says certain things which are offensive to natural justice. If I were to republish these things, I would be causing an injury to Mr. Smith, which I have been alerted to, not only by my own training, but as confirmed by Mr. Mendez and Mr. Das. And indeed, I've been cautioned by Mr. Smith's attorneys and other persons, attorneys at law acting for other parties, that the publication of this matter would be offensive and injurious to their circumstance. Let me stick a pin and remind you, this is not the first time that a matter like this would have been dealt with. You must recall Mrs. Kamla Prasad Bisesa laying the report of the Central Audit Committee into Mr. Ashwin Creed. and then that matter going to court, and then the honorable judge ordering that the report be set aside, and effectively the taxpayers then paid Mr. Creed his costs, as far as I remember. That is the similar case in Privy Council decisions, Supreme Court of the United Kingdom as well, and throughout the Commonwealth. So I am not acting capriciously. It is very important to note that this case is different from the Invaders Bay opinion. In the Invaders Bay opinion, the JCC matter, which is on appeal to the Privy Council right now, the Court of Appeal ordered the disclosure of the opinion. All that that opinion demonstrated was that Attorney General Ram Logan was specifically advised that the disposition of the Invaders Bay land was wrong in law and he ought not to have done it. It did not make a reference to persons' rights. It did not speak to the defamation, libel, injury of character that would be occasioned as a full disclosure in the Darryl Smith matter will cause. But today I will send out, immediately after this press conference, that slightly redacted version of the opinion so that you can see for yourselves why this matter has gone the way it has. Specifically, permit me to now say that this opinion covers a very important series of advances in law. Very specifically, it notes what the terms of reference are. It confirms the very time frames that I have just reported to you, the immediacy with which the Prime Minister acted. It goes through the law, which puts into the fact the duty of the committee, whether voluntarily set up, whether as a commission of inquiry, whether as a tribunal, it puts forward the duty of the committee to act with fairness. And it goes on to specify what the law says, that it is a well-established legal principle that a person should not be criticized in a public report without first having been afforded a fair opportunity to respond to that criticism. It is at this point that there is confusion in the population's mind, largely because of the reporting that the Prime Minister supposedly said that Mr. Smith was not interviewed. The Prime Minister never said that. The Prime Minister said that Mr. Smith was not afforded the opportunity of being interviewed in relation to the criticisms put to him by certain people in the context of the report. In other words then, being interviewed once as opposed to the right to a fair hearing or to natural justice stand separate and apart. The opinion goes into something called Maxwellization. Maxwellization comes from the case involving Robert Maxwell in the early 70s. It's referred to as the Pergamon case, and that is a reputed judgment. And it goes on to the fact that there is a process of providing an opportunity prior to publication of a report of this type. Effectively, that case, Lord Denning says, that inspectors can obtain information in any way they think best, but before they condemn or criticize a man, let me repeat that, before they condemn or criticize a man, they must give him a fair opportunity for correcting or contradicting what is said against him. They need not quote chapter and verse. An outline of the charge will usually suffice. That has been repeated in numerous authority to be found across the Commonwealth and indeed in our local jurisdiction. And very importantly, to be fair, the opportunity to respond must be given before the decision maker has reached a concluded view. If an opportunity to respond to criticisms is given to a witness, then giving evidence to an inquiry, the decision maker need not put its tentative conclusions to the witness to allow further comment. But if the decision maker proposes to criticize a third party who has not given evidence or who has had proper criticisms properly put to him, he must be given an opportunity to respond. The law applied to this particular case demonstrates that the procedure employed, and this is, I'm quoting now specifically from the opinion at paragraph 27, As a consequence, it is our advice that the procedure which has been employed thus far is likely to constitute an unfair process, and the request for comments after the fact of the report being finalized is likely to be found to be unsound and irrational if the authors of the report are not going to consider them. The question, the opinion says, is how can this be remedied? One option was and is to discard the report and to reconvene a new tribunal, which could then embark upon a procedurally appropriate process. The advantage of this approach is that it removes any possibility of legal challenge based upon any missteps which might have previously occurred. The disadvantage of this is obviously that all work done to date would have been wasted. A second option is that the decision maker in question, that is the committee, can be reconvened to now consider whatever comments or complaints have been advanced by the former minister. Further to this, the former minister could be written to and advised that the draft report is not going to be published before his comments are considered and that his comments will be reviewed. Any other concerns as to fairness can be addressed by the committee. The advantage of this approach is that the existing work will be salvaged. The danger in this approach is that the findings of the draft report may be used to impugn the committee on the basis of apparent bias. The findings of the draft report have not been expressed in a provisional or preliminary matter. Let me repeat that. The findings of the draft report have not been expressed in a provisional or preliminary matter. On the contrary, many of the findings therein, including those contained in the Salmon letters, appear to be made in a fairly conclusive term. Although the draft report has not been disclosed in its entirety, there is a possibility that it may be disclosed at some stage, and in any event, the extracted findings from the Salmon letters have already been disclosed. This, ladies and gentlemen, stands as to the rationale as to why this report has not been made public. Let me be very careful now to thank the committee itself, because the committee in its report, specifically at the end of its report, noted that they considered their remit not a tribunal type exercise, but that they noted that their report in and of itself could be subjected to an allegation of a breach of natural justice. The committee put that in black and white at the end of its report. What happened here, and this is a matter of legal interpretation, what happened in this particular matter is that, unfortunately, the committee's report in its draft report went a little further than it should have. The Prime Minister has publicly confirmed that he, as Prime Minister, exercising his prerogative and his privilege to appoint and remove persons as ministers, that he has acted in this matter. That has been the case since April 10th, 2018. The Prime Minister was faced with a potential of throwing away the entire work of the committee or of reconvening the committee, where the committee would have been the subject of an allegation of apparent bias. In those circumstances, the Prime Minister chose to end the matter at this point, from the Prime Minister's perspective. However, ladies and gentlemen, the Permanent Secretary, the head of the public service of the Office of the Prime Minister, has been engaged in a process of treating with the public service side of this. I can also confirm that that includes the development of a sexual harassment policy. That also includes the work that the Minister of Labour herself has publicly spoken to as the legislative and other structural public sector management of allegations of sexual harassment. I will remind you that there is case precedent for this. In the Ashwin Creed matter, notwithstanding Madam Justice Dean Armorer having thrown out the report of the Central Audit Committee, the public service engaged in a disciplinary process. That process only came to an end when Mr. Creed resigned. You will recall that that process continued. I'm able to tell you today that the Prime Minister's function having been achieved, it is certainly open to me as Attorney General to take another step. And that step, certainly as AG, is that I can continue in any form or extension, in any such persons as I may select, to deal with this matter and the report and function. I am at the cusp right now of inviting a suitable person. I am leaning towards a retired judge or Silk, a senior counsel that has expertise in this particular area, to consider the very narrow issue of the allegations of sexual harassment. The Prime Minister himself indicated that he wanted to publish the report. Indeed, the publication of the report was only halted when the draft report was delivered and it was discovered that natural justice was not complied with. The Prime Minister has acted in full public discussion. There is a deep confusion, obviously, between this he say, she say. It is a fact that Mr. Smith was interviewed. He was interviewed. His attorney has confirmed that. I have confirmed that. Certainly, I have confirmed that to the reporters that I have spoken to. Indeed, the Newsday carries a very different version of events from the Express. The Prime Minister has never said that Mr. Smith was never interviewed. The Prime Minister said that the criticisms required to be put to Mr. Smith in the context of what I specifically explained to Ms. Wren in particular is the Maxwellization principle. That was not complied with. I will be making this report public. The Permanent Secretary is here to confirm to you, if you should so desire, that the process adopted did not involve a tribunal-type equation where you could cross-examine the allegations that were put to you. That process did not happen in this particular event, and the Permanent Secretary can also confirm for you that there is a public sector side of this equation which is uninterrupted by the production of this report. As Attorney General, I intend to request specific action in relation to the narrow issue of the allegations of sexual harassment in this. This matter will have to be the subject of careful process. I can confirm to you that I have advised specifically that this report is not to be published. This report cannot be published because the report is defective insofar as natural justice is concerned, and bearing in mind the precedent set from the Maxwell principle comes straight down to the Ashwin Creed case. The only people that will have to bear the brunt of the wrongful publication of this report will be the taxpayers. We have had this issue decided in court, certainly in other jurisdictions on many occasions, and indeed in Trinidad and Tobago. And that is the reason why I have advised the Prime Minister that the report itself cannot be published. I specifically, in discharge of the considerations of Section 35 of the Freedom of Information Act, intend to make a slightly redacted version of this opinion from Mr. Mendez, Senior Counsel, and Mr. Das as Junior Counsel, public, and I will put that out today into the public domain. One has to be very careful as a holder of an office to balance the competition of rights that are in issue. Whether you like it or not, there is a discharge to be to be considered. There is a judicial review application brought by Mr. Devant Maraj in this matter, asking for the disclosure of the report. I am conscious that that matter is still in the court. And then there is obviously the risk of judicial review, exactly as Ashwin Creed did, that any person mentioned in that report can exercise if what we know to be a faulty report is put into the public domain. May I invite your questions either to me or to PS Suite or to both of us in this matter?
The Maxwellization
Yes, no, you've got it right. Sure. Thank you for the question, which is very useful to clarify perhaps a misunderstanding that people may have. The decision maker in this matter, that the Maxwellization case, the Creed case, any one of the cases referred to, are the committee members. There is no decision on the back of this report. The Prime Minister acted already. He acted on the 10th of April 2018 in dealing with Mr. Smith in his view as Prime Minister, and he and only he has that privilege and prerogative. What the cases refer to is the person who has decided to write the report. The decision maker is the person who's writing the report. What is wrong in this report, as I've read to you from the opinion, is that the report is not couched in tentative or preliminary language. It is conclusive. We find 1, 2, 3, 4. Indeed, that was put out. Somebody appears to have that in the public domain. It certainly doesn't come from the Office of the Attorney General or the Office of the Prime Minister. So the decision maker is the committee. It is the decision to conclude the report that is an issue. The report makes conclusions of fact and findings. The report says, and it's in the redacted version of paragraph 6 of this opinion, we find 1, 2, 3. We find ABC. And it is that finding as a decision maker of making those findings that is on test here. No, they're not. Their sole job is to receive the report. The Salmon letters which were written say specifically the Prime Minister intends or desires to publish this report. And there are negative reflections made of you in this report which must be put to you. So that was made clear. Their only decision is to publish the report. The decision maker in this instance is the committee. The committee decided to conclude certain facts. So they come up with conclusions of fact. And what is impugned in this fact-finding process is that they went too far. And they did so, I don't think, in any willful attempt. Indeed, these are three very reputable personalities in Trinidad and Tobago. I think that this is a matter of just having gone further than the Maxwellization permits. And I dare say that is evidenced by the statement of fact. It's in the written report where the authors of the report say, we consider that this report may be offensive to natural justice. And they made that caveat on the basis that they felt that their mandate didn't permit them to go further. What was wrong in this exercise is that they had come up to conclusions of fact in very precise terms, and that they had effectively gone too far. So let's treat with that. First of all, your statement leading to your question is premised upon the fact that you accept that the conclusion of the committee, which opinion has now said went too far, without fair process, is correct. Your question starts off upon the premise that what the committee said is true. The committee in its report says, we recognize that we have not complied with the full process of natural justice and that we may be open to the criticism of a breach of natural justice because we didn't allow for people who were being criticized to test the veracity of the criticism. In other words then, Rhea Tate arrives and gives a statement to John Brown. Rhea Tate leaves. John Brown is not permitted to say, well, you say A, B, C, D, E, what about X, Y, Z, to test the veracity of what is being said. It cannot be an exercise of hearsay collection because then you're just collecting a number of allegations. Now let's deal with your point about smelling something wrong and whether something's going on. Right. So what this case involves, the matter which is under question is the payment of $150,000 in a trade dispute, which is before the industrial court. The matter involved a request for $225,000. The ministry's position, the CPO and the Ministry of Sport was, you were unfairly dismissed. We accept that the summary dismissal was not good enough. We are offering $75,000. They then went to Kwamina, who dealt with the matter, gave written advice. Kwamina came up with a position of saying $150,000. The coloring of the allegation inside that case is there was supposedly sexual harassment. As we see every day, there is a shocking event that happened to me in my personal life last night, where I was alerted to something that my political opponents are trying to concoct. It was quite interesting. I've seen the evidence of their maneuvers with Dr. Rowley in 2014, that the Honorable Prime Minister, according to Vanilla Allen Toppin, and according to the attempts that they had to have people swear affidavits as to whether Dr. Rowley's father was guilty of rape and Dr. Rowley himself rape in producing their own children. I mean, this is the most disgusting form of personal attack that you can have. The colorings can go from very offensive, as we've seen laid against Dr. Rowley, and some of us in public life experience these things, down to a case where someone is asking for money and make an allegation. That's why I have said today two things. Number one, the permanent secretary will confirm that there is a process to deal with the public servants that have managed this exercise. I can tell you that the report produced by the committee does not name Mr. Kwamina or the Prime Minister. Yes, they have come to something which I think is premature, that the permanent secretaries and deputy permanent secretaries have something to answer. The public service process will continue and is in gear, and I can tell you that I myself today will certainly be looking at the allegation of sexual harassment at the Office of the Attorney General. This matter really has been dealt with out of the Office of the Prime Minister procedurally, simply because the Prime Minister commissioned a report. The Prime Minister didn't interview anyone, he didn't participate in who is to be examined or cross-examined, etc. The Prime Minister's role is at an end. In fact, it was at an end, in my view, quite respectfully, since April the 10th, 2018. So this process is continuing. What we have going on, because I have to balance the rights as Attorney General between the allegations made in the report, the right to fair hearing, knowing that it is faulty, with the public dynamic, there is a maelstrom that is in effect. And I must balance those things. I cannot subject myself to the Kamla Prasad treatment of this issue, where the taxpayers are exposed to legal proceedings, resulting in Mr. Creed walking right out of court and promptly encashing the cost that he may or may not have been entitled to. Sure? P.S.?
Okay, good afternoon, everyone. Well, obviously, I'm not going to speak to the report, right? What I would say is that there are two matters really that covered this whole issue. One was the summary dismissal, and the other is the allegation of sexual misconduct. Now, we have to put it in a little context in that the person we are dealing with is what we refer to as staff personnel to the minister. There are certain classes of individuals, such as the chauffeurs, personal assistant, etc., that are personnel to the minister, and those persons are hired on the request of the minister. There's no recruitment process or evaluation process for the hiring of those individuals. Those individuals, once they come into office, they would be given a contract, for instance, it may be 3 years, or on the end of the term of the minister, whichever is the shorter. So in a case of if the minister is dismissed from office or resigns, their position automatically comes to an end. The practice that have generally taken place within the public service in the hiring and removal of those persons is that we have a term where basically they came through the back door, they leave through the back door. That is, they came in on request of the minister making a request to the permanent secretary, and they're brought on board. They don't report to the permanent secretary. That permanent secretary does not do that person's performance appraisal or evaluate their performance in any way. And if the minister chooses to end that person's employment, that person's employment is terminated, and based on their contract, whatever terminal benefits are due to them are paid, right? And that has been the normal practice over a number of years. In this instance, you had someone questioning that practice and going to court, and there's the other element of sexual allegations of sexual misconduct that brought in, right? So coming out of that industrial court matter and the advice that would have gotten from the legal person and the attorney general explanation in terms of the payment of individuals, it calls into question now that practice that attained in the past, and how do you move forward? So coming out of that, we would have had discussions at the board of the permanent secretaries and heads of department on a need to address this. We would have engaged the CPO, because the CPO is considered the employer for persons on contract. And the CPO coming out of that would have looked at the current contract that are offered to those individuals with the intention of looking to see how do you balance those rights and expectations that come under industrial practice and coupled with the way the persons were brought on board and current practice. So the chief personnel officer would have developed a policy, and that policy has been put to the Minister of Finance, because he would deal with terms and conditions of employment, and once they have reached some sort of revised policy on that, something will be taken to cabinet to deal with this matter of hiring and dismissal of persons and how best to treat with it. On the other aspect of the sexual allegations of misconduct, the Attorney General would have spoken to it. We have currently on the Ministry of Labor's website a policy dealing with sexual harassment. The Ministry of Labor is currently in the process of what they call an implementation stage, and that implementation stage is really to deal with going out to not only in the public sector but also the private sector to try and raise awareness of that particular policy, and to also do some sort of research in gathering baseline data dealing with sexual harassment in the workplace, etc. So that's something that is dealing with on the Ministry of Labor side.
Anyone else?
Yeah.
Yes, you mentioned terminal benefits. What would be the terminal benefits for the person who is deceased?
I can't say offhand. I'll have to look at the individual contract of the person, because they would have, it will depend on how long you are in service and whether you cross a certain number of months, whether there's a gratuity payment, etc. But I can't say offhand. I know generally you have to complete your contract, and there's a 20% gratuity. And if I recall correctly, normally there's like 1 month's notice or something like that dealing with it. But I don't want to be quoted on it, but I don't have the contract in front of me.
You also made mention of a process being underway right now to deal with the other cases and other public servants in relation to the sexual harassment issue and whatever issue, and certainly they cover. Could you give us a little information?
That's what I sort of clarified, in that there was no, in terms of the summary dismissal, yes, there was a summary dismissal, and when it went before the court, obviously the state lost its matter before the court for the summary dismissal. But what I was trying to explain in the past is that that has been the practice with persons who were hired in that fashion, in that the minister would say, I want this person as my driver, and then he would come and say, okay, this person has been late, I can't work with him anymore, I want to change my driver. And basically, the summary dismissal has been the practice because that was the way the person was hired in the first place. But obviously, as industrial practice develops and you have jurisprudence taking place, then you will have to adjust the manner in which you treat with it. So that's what I meant, but what's happening on that. Exactly.
Just to lend some clarity, you must appreciate that this process has been complicated by the large elephant in the room of people saying, look, anything that you intend to do on the back of this report is a problem. The Prime Minister came to the public and said, look, I want to bring this thing to the public. My hands are open to you now. But at that point, severe lines in the sand were drawn, strong lines in the sand, deep lines in the sand were drawn, and the Prime Minister could not act. The Prime Minister has at all points spoken to these matters. So whatever is to spring in the public service side and that is in gear is obviously constrained by the fact of, well, what can you use or can't you use? And then there's a process to treat with that. So the point is that this has been answered on umpteen occasions. I understand and appreciate some of the confusion in the public domain, but this is not a society where you can just say, well, here, look, have everything. That's not the way the law operates when you're treating with people's rights. And you have an obligation to consider the balance of rights. Look at the example of Malcolm Jones. I received written advice from the Queen's Counsel, whose junior counsel was Gerald Ramdeen, in the Malcolm Jones matter, to tell me the case is dead in the water. The evidence is wrong. We're going to lose the case. Withdraw the matter and settle. That came from the UNC's attorney at law as well. And then afterwards, I came into round condemnation that I should not have let the case go. So what do? Listen to the people that you retain, and you remember, I took the step in that case of not dismissing the attorneys at law. Usually, political parties came in when Mr. Ram Logan became attorney at law. He fired Douglas Mendez and other people in the Ish and Steve matters. What happened next? No extradition. I learned my lesson. There were attorneys at law acting in the matter, keep them. So at least they can't say, you sabotaged the case. They came to me and said, look, we have to end this case, we're dead. And then afterwards, they're the same people on the outside saying, well, they shouldn't have ended the case. So I'm trying to give you an example of, you have to be careful how you act in these matters, because there's always a chorus of criticism that comes at you. You are entitled to the presumption of innocence. The process must be fair and clear, and that is what has to be done here. The Prime Minister has been expressly clear at all points in time in how this matter was dealt with, and the Office of the Prime Minister, from my point of view, respectfully discharged its functions on the 10th of April 2018, as only the Prime Minister has that privilege. Well, Mr. Kirkwaite is a gentleman who has been an advocate for a number of causes, except a few. I have never heard Mr. Kirkwaite call for criminal investigations into certain members of the UNC, and I have my suspicions why. if there is to be a criminal investigation, the police are entitled to deal with whatever the police are entitled to deal with. Certainly, let me put this in stark position. The worker herself did not make a criminal complaint. That has got to say something to you all. The worker herself has not made an allegation, and Commissioner Griffith put that into the circulation as to the point that he's not in an investigation because no report was made to him. Civil law and crime are two different things, you know. You can end a matter in civil law any day, any time. It does not stop the police from doing what they have to do, as you're well aware. Yes, a crime has no period of limitation, and a crime is not the subject of a civil matter. The civil law and the criminal law go side by side. I'll give you an example. Anand Ramlogan had defamation proceedings against Keith Rowley, which he withdrew and which was settled on the allegations raised in Section 34. Springing from that particular matter, there were certain allegations of witness tampering. One could allege that the witness tampering didn't happen because the civil law ended. It was a witness tampering in that matter. That matter is no longer before the court. Mr. Ramlogan is facing a criminal charge for it. No, respectfully speaking, if the DPP or if the Commissioner of Police, where the DPP is not required, consider that a crime has been committed, nothing stops their jurisdiction from flowing. But the question is, where is the report? I mean, I can't go and complain about the sexual harassment. It didn't happen to me. I could complain about sexual harassment as a matter of fact. I've never done it. But the point is, people have the right to say what they wish to say.
EJ, just for the record, the settlement was given on the allegations of sexual assault, or was it for wrongful dismissal?
It was the claim before the industrial court was for wrongful dismissal. The coloring inside of that was an allegation that I was wrongfully dismissed because I was supposedly being sexually harassed. The settlement which was achieved and accepted went down from $225,000 to $150,000, and that was to deal with the matter of unfair dismissal. There was no grievance filed in the ministry process as to sexual harassment. There was no criminal complaint for assault that was raised. This matter found itself in a claim saying, I want money. I want $225,000. Let's get this clear. There was no, I am sexually harassed and I want to make a complaint in the process that the ministry has. There was also not an assault charge brought or a threatening charge brought or a text message which can be cyber harassment, etc. None of those things happened. Well, apparently they came together in the form of an affidavit or in the form of evidence before the court. I was unfairly dismissed, and I'm saying it's because I was supposedly sexually harassed. Where is the complaint? In the multiple other arenas that exist. People are asking now for the public service to come up with statements of sexual harassment policy. There is a sexual harassment policy. In this ministry, we have one. You can go and report it to the permanent secretary. You can go to the Trinidad and Tobago Police Service and say, this is what I have been subjected to. I am being harassed. I am being threatened. I have been assaulted. Somebody touched me. An assault, a battery, all of those things flow from matters such as this. This claim was brought effectively to say, I've been summarily dismissed. The evidence shows they wanted $225,000 and that they accepted $150,000 and went off. Yes, of course. Ria, if I were to show you my telephone and show you the messages that I get. No, I just know, but there's a gender issue in this country, right? I can tell you as a matter of, yes, there's a power issue, and people who are in power, people who are in public life find themselves in the circumstance, and yes, there is Me Too, etc. Pardon? Yes, and if that abuse is met through a process, report to the police, sexual harassment reporting, a whistleblowing complaint. This matter was taken to the industrial court. This matter involved somebody saying, I've been summarily dismissed, and I say I've also been sexually harassed inside of that. And I want, through discussion, $225,000. That's what this matter was involved. There is, according to the Commissioner of Police, no report having been made to the police. It was open for that to be done. And there's, according to the ministry's records, no report, as far as I'm aware, of sexual harassment having been filed.
But AG, all these are being done by the accuser.
I don't think that those are errors. That's a matter of choice. Let me remind you, the accuser was represented by people who know what to do. I don't think you can call that an error. Could you? If you're advised by people skilled in industrial relations who have dealt with matters such as this, you cannot call that, most respectfully, an error.
Right. But even they would do those things. Why settle it down? Why settle? Is that somewhat of an initiative?
I'll answer that. I'll answer that. There was guilt in a summary dismissal. The advice, the written advice coming from the attorney at law is you're dead in the water. You did not follow proper process. The cases demonstrate that even if you work for one day, you will get damages from the court. It was a foregone conclusion that they would lose the case for summary dismissal. So why on earth would you go to trial? You tell me why. If your written advice from an expert in the arena is you are guilty of summary dismissal, you will have to pay money. What do? Go to court and let the court say you should have known, and we're going to exacerbate the damages and we'll bump this up because you could have settled this thing long time ago. What kind of foolishness would that be? Let's be frank in this discussion.
You would admit, though, that sexual offenses is one of the most reported crimes.
Far from. I will admit that sexual offenses reporting has climbed significantly. And apparently you weren't paying attention to my advocacy to create a sex offenders registry and all the data that I put in the public domain. Nor apparently are you perhaps au courant with what the Children's Authority is saying, which is an explosion of allegations of sexual misconduct. Nor are you apparently paying attention to the 27,000 cases that are before the courts right now.
And this happened in time that was more.
This happens every day. This happens every day. Let me be clear. I have taken a very strong and robust stance against sexual misconduct, against crimes, against sex offenders. I went as far as proposing for the government that if you're a sex offender, it should be made public, it should be stamped on your passport, it should be treated with. We had a long joint select committee on that. The movements in the nonprofit organization sector did not agree with me. They felt that that should be softened. We should not put in the passport or public identification without certain measures, and we did that. So our record as it relates to sexual offenses is a very good one in saying that we abhor these matters.
You made mention repeatedly that the Prime Minister did not say Mr. Darryl Smith was not spoken to. There's a clipping of the Express and Media carried this. I just want to read it to you.
Sure.
The report, by that I mean this is the Prime Minister, they came to a conclusion negatively about Mr. Smith without talking to him.
Stop. Does that say he was never interviewed?
They say he was not spoken to.
Yes, so they came to a conclusion without talking to him on a subsequent occasion where natural justice required that he be met with in the fashion that Mr. Mendes has advised. I know, but you see, the Prime Minister, as you all are very aware, first of all, is that in quotations?
Yes, it is.
Right. So the Prime Minister said that. Is it in the quotations of the entire conference? I can stand up here and you will tonight give 30-second clips, 22 seconds max, as to what I say or don't say. It's not the entire conversation. I certainly had 3 conversations, at least with Ms. Wren. There is 1 paragraph in the Express newspaper today as to what I said or didn't say. That belies the fact that I've had 3 conversations and explained the matter in depth and in detail. Sure. I accept what you're saying, but I'm confident that I, who watched the interview, I'm also aware that questions were coming at the Prime Minister. And what you do is you answer quite quickly. First of all, the Honorable Prime Minister is not an attorney at law, nor is he going to be centered upon the fact, well, I said X, or I said Y, or I said Z. I will take the caution as I've read out today, and I'll publish for you today to put out all of those particulars for you. But quite respectfully, the Prime Minister, in answering questions, answered as he always does, frankly. Mr. Smith was interviewed. They did not put the allegations to him in the continuing process that they ought to have in a subsequent interview. Natural justice does not end with, hey, I spoke to you once. It does not end there. Sure, I appreciate that.
You made mention of a lot of things that the committee could have done. Did they have the authority to go back to Mr. Smith and question?
The committee was very clear that they felt that they didn't have that authority. But by that point, they had produced a report which had gone too far. So effectively, it became a lame duck.
If they didn't have the authority to do it, and they didn't do it, and that breached natural justice, then how is it that they breached natural justice?
Okay. First of all, law school is quite a long exercise. And I say that genuinely, right? These are born on the back of decisions of the High Court, the law evolving, the Court of Appeal, the Privy Council. These turn upon facts and details, some of which are libelous and offensive and have breached natural justice. They would be made clear if those things came into the public domain, but they would injure the people against whom that caution has been exercised, right? So unfortunately, I do accept that the best case scenario is to lay it all open, but then you mash up people's name and reputation and perhaps wrongly, okay? The fact is that this exercise went too far. The committee, in its written report, did say that they expressed a caution that this report could breach natural justice, and they wondered whether its publication should happen because of that. They put that out. As Mr. Mendez and Mr. Das have advised, this position is one which went too far. Their written opinion, which you will have a copy of very shortly in its slightly redacted form, will tell you exactly why they say that, and they will assist you by identifying some of the case law which says all of that. Mr. Mendez didn't act for the Ministry of Sport. Are you asking how much I paid Mr. Mendez? I can't recall receiving his bill yet. He's notoriously late on providing bills. You could ask him if he wanted to send it, but I would prefer to receive it in due course. No, I think that this is a genuine issue. I think that there's concern for this type of conduct. I think there's legitimate concern in the public domain as to the transparency of public enterprises, ministries. I think that sexual harassment is real. I think that we need to be diligent in how we manage these things and to find a balance. What our political opponents will or will not say on a platform is a different story. And they are entitled to take whatever shot they want at it. Quite legitimately, this is a democracy. Anyone else?
Are you in a position to say conclusively what the next step will be? You gave a list of recommendations. I think the first step would be that the report is discarded and are you convening? But are you able to say what the next step will be?
Sure. The report must be discarded. We, the Office of the Prime Minister and the Attorney General's Office, will not be disclosing the report. That is the subject of a legal challenge by Mr. Devant Maraj, who wants a copy of the report. We'll deal with that in court. No. If the committee reconvenes, there is the obvious argument that they're going to face of apparent bias. You have come up with a conclusion already, which in fact you put in writing, and therefore you ought not to consider this matter because you have prejudged the matter. Anything I say to you is not going to change the fact that you made up your mind already. That's what the apparent bias argument will be. So the reconvening of the committee would not be fruitful because we'll obviously be met with a whole set of legal expenses as to whether there's bias or not. What the permanent secretary at the Ministry of the Prime Minister, the head of the public service, will do is to continue the exercise of the investigation into the public service side of the equation. And what the Office of the Attorney General will do is that we will commission an independent, narrow position to deal with the allegations of sexual discrimination.
One more question, AG. The opposition has just sent a settlement, right? And they are calling for the Prime Minister to resign over the Darryl Smith affair. And they said the attempt by Attorney General Faris Al-Rawi to defend the indefensible shows that the entire cabinet is following Procedural in this trouble. Any comments on that?
Typical UNC wish listing, full of nonsense and hot air. I mean, they will say what they have to say. Mrs. Prasad Bisesa is certainly not qualified to advise anybody on this matter because the taxpayers footed her advice already in the Ashwin Creed matter. And in that matter, I'd like to tell you, you are obviously aware that that matter concerned much more. There were allegations of murder, theft, corruption, and Mrs. Prasad Bisesa was recently seen hugging up the main target of that exercise. So I take no advice from Kamla Prasad Bisesa other than to tell her, give back the Senior Counsel Award. Okay? The committee is now funked us. They've ended their exercise. Okay? Ladies and gentlemen, yes? I think Mr. Smith is itching to give his side of the story. Certainly in his circumstance, he'd want to have his name cleared. He'd want to have his side of the story. He has been proverbially put into the position of a market crab. His name is calling left, right, and center. He's been the subject of action, and he can't come out and defend himself openly. He wants to meet his accuser in the forum where he can. So I think, you know, from a personal level, obviously for anyone, they would want to defend themselves. I can't advise Mr. Smith on what he ought to do or not. I mean, I have faced many a criticism publicly, and I have met it as best as I can. It's never an easy situation. That would be a personal choice for Mr. Smith. I get no pleasure in watching Mr. Ramdeen or Mr. Ramlogan in the circumstance that they're in. I don't speak about those matters quite publicly, as you will notice. In fact, there are many people in politics who say that I ought to be on platforms chastising on a daily basis, but you will notice that I don't do that. Okay? Thank you. It certainly wouldn't, there would be no action to be taken against the AG or the Office of the Prime Minister, because we have those reports under embargo, because we've been advised to do that, and I'll make it clear we are not releasing those reports unless a court orders otherwise. The release of that report is being requested by Mr. Maraj, as he's entitled to request in his FOIA judicial review application. Okay, thank you very much, everyone. Have a good afternoon.